Hi everyone, I'm attorney Aiden Durham with 180 Law Co. in Denver, Colorado, and welcome back to All Up in Your Business. In this episode of All Up in Your Business, I'm going to talk about trademarks and copyrights, and especially what they mean when it comes to a logo for your business. But first, let's address the fact that things look a little different around here. That's right, there are some changes going on behind the scenes at All Up in Your Business. I have relocated to beautiful sunny San Diego, back to my hometown. So bear with me as things might be changing in the background while I'm still unpacking and getting stuff organized and figuring out where things are gonna go. You might also be wondering, what's going on with this girl's hair? Well, for those of you who have wavy, frizzy hair, you'll understand that if you live in a place with even a touch of humidity, just straightening doesn't work. So I'm embracing it, and this is what I look like now. So we're all just gonna have to get used to it. All right, and last thing, before we get into it, be sure to like, subscribe, and share, and check the description for more information and additional resources and stuff too. All right, so in my last video, I talked to you guys about some things that people commonly think are trademarks, but that are not actually trademarks. And in that video, I mentioned really briefly that sometimes something can be both protected by trademarks and by copyright law. And most commonly, this applies to logos or other kinds of designs that are used for businesses. And this, of course, raised a lot more questions from you guys about, should I worry about copyright protection for my logo? Or should I be copywriting my logo? Or should I get it trademarked? And some more questions coming up about how trademarks and copyrights work together, specifically when it comes to logo designs that are used in a business. So that's what we are going to dive into today. Specifically, should you worry about a copyright, a trademark, or both when it comes to your business's logo? So a little quick background for those of you who may not already be familiar. A trademark law protects words, phrases, logos, designs, symbols that are used by a business to indicate the source of their goods or services. Basically, it prevents your competitors from using your trademark on the same or similar types of goods or services. A copyright, on the other hand, protects creative and artistic expressions. And a copyright prevents anybody, aside from the copyright holder, from using or distributing the copyrighted work. And so it's not completely uncommon for a logo to be protected under both trademark law and copyright law, because a logo can be used as a source indicator for a business. That's how commonly a logo is used. But a logo can also be considered a work of art or a work of creative expression. So a logo or some kind of a design that's used for a business can fall into both trademark and copyright categories. But that's not always the case. In order to be protectable under copyrights, the logo has to have some creative or artistic element to it. It can't just be stylized wording or stylized text or just common shapes or symbols. It must possess at least some minimal degree of creativity. Now, what does that minimal degree of creativity mean? There's no real answer. I can't tell you what that degree of minimal creativity has to be, but it has to exist. Essentially, it's like, we'll know it when it's there, we'll know it when it's not there. And when we don't know is when these questions go into the legal process, and that's how we decide this thing did have some creative expression or, enough artistic element to it versus this thing didn't. But for the most part, the thing that you want to remember when it comes to copyrights is that familiar designs, common patterns, familiar symbols and shapes, and then just designs and typography or font or text, those things aren't going to be enough of a creativity or an artistic element to qualify under copyright. So let's take my 180 Laco logo, for example. This logo is a trademark because I use it as one. It's a symbol and some words and a design that when I use it, I'm using it as a way to indicate to the consuming public that this logo means you're working with me. When you see this logo, that means you're dealing with me. So it's a trademark. But, it's not just words. It's got this little, circle to it and a little bit of design element to it. But it's not a copyright. It's not protected under copyright. It's really just a circle, kind of a half circle with some dots and the 180 in it and some extra words. So while there is some design and creativity to it, it's nothing unique. It's not an artistic expression. I'm just taking commonly used shapes and make them into something that is a trademark for me. So in this case, my logo doesn't really qualify under copyright protection, but it is eligible for trademark protection. For the record, I don't have a registered trademark for my company's logo. Frankly, it's not that important to me. Again, it's just the name and a semicircle and stuff. So, you don't have to register every trademark. I do, of course, have 180 Laco, the name, trademarked. But anyway, so all of this to show you guys, this isn't really a copyright, but it is a trademark. But then on the other hand, let's look at this very popular, well-known Starbucks logo. Again, of course, this is a trademark. We see this logo on a cup or on a bag of coffee or on the side of a building, and we know this product or this service, this thing is coming from this company that we've recognized as Starbucks. So it's clearly a trademark, but it's also protected under copyright law. Starbucks does actually have a registered copyright in this symbol, in this design too, primarily because of that, the mermaid girl. If it wasn't for her, this wouldn't be a creative work. It wouldn't be eligible for a copyright. Just the words themselves, the Starbucks, around the logo, that doesn't do much for copyright. But the girl, the image herself, that in itself, it has enough degree of creativity that it in itself is considered a work of art, essentially. So Starbucks has a trademark, but they also have a copyright for the same symbol. But again, remember, the trademark and the copyright, they do very different things. So whereas the trademark goes, they have a trademark for the logo, obviously, but they also have a trademark for Starbucks, just the name on its own, because they want to protect that too. Whereas this copyright for the logo, even though the copyright might include the name Starbucks in it, the copyright's not really protecting the Starbucks name. It's not protecting the Starbucks brand in the same way that a trademark does. So why does all this matter? Again, trademarks and copyrights serve very different functions, and they do very different things. Trademark protection, for the most part, it only extends to the goods and services that are registered, the goods and services on the trademark application. That's why we can have things like Ace Hardware and Ace Bandages. Ace Hardware has a trademark for Ace Hardware. Ace Bandages has a trademark for Ace Bandages. They coexist, even though they are essentially the same name, because they're completely different and unrelated goods and services. So the trademark, for the most part, only extends to the goods and services with which it's registered. Copyright protection, on the other hand, gives the copyright holder, the owner, the exclusive right to distribute, reproduce, reuse, copy the work at all in itself. So it doesn't have anything to do with products or services that it's used on. It's a copyright in and of the work of art itself and protects it against any kind of unauthorized or unlicensed use. So that's why companies will have both trademark registrations and copyright registrations over the same thing, because they want to protect it in different ways. And also you get different rights with trademark and copyright protection, different kinds of damages, different things that you're entitled to if you're involved in a lawsuit for trademark or copyright infringement. The rights differ and your options and damages are different. So again, it is possible to sue somebody for both trademark and copyright infringement over the same thing and get two very different kinds of damages out of it. So it can be very beneficial to do both. So when it comes to those of you who are wondering, should I trademark my logo or should I copyright my logo? First of all, you need to think of how you're going to be using it. Are you using it as a trademark? Then probably you want to focus on the trademark registration. If you're not sure if you're using it as a trademark, check back to my last video of that's not a trademark, and I go into a little bit of detail about like how you have to use something as a trademark in order for it to be a trademark. But so if you're going to use it as a trademark, then that's usually where you want to start, because that's the priority. And then if it qualifies as a copyright, then you might want to explore that too. If you're not using it as a trademark, if it's really just a design, but if it has that sufficient artistic or creative element to it, then the copyright registration, copyright protection would be more appropriate, because a trademark wouldn't apply because it's not a trademark. But if you really are in a situation where your logo does count as a trademark and a copyright, then it can be beneficial to register both and take full advantage of the intellectual property rights and options that are available to you. So in terms of how you do this, again, very different things, very different processes to go through. So a trademark in the United States is registered with the United States Patent and Trademark Office. That's at uspto.gov. A copyright, on the other hand, in the US is registered with the United States Copyright Office. And that's, I think, copyright.gov. The application processes are very different. Again, with a trademark, we need to show that we're using it in trade, that we're using it in commerce. It has to be used as a trademark, and we have to provide that information with the application. We have to say what kinds of goods and services it's being used in connection with. Whereas the copyright application, it focuses much more on the details of the work itself, because that's what the copyright is protecting, is the work itself. So you don't have to necessarily give proof of how you're using the copyright. It's just much more question about the work itself, and the process is a bit faster. Typically it's going to be less expensive to do a copyright registration. The filing fees are much less compared to a trademark registration. But again, don't just focus on the cost. Just because a copyright is going to be cheaper doesn't mean it's going to do you any good. If what you really need is trademark protection, then registering a copyright, it'll hurt. It might help, but it's not going to give you any trademark protection. So really, if you're unsure of whether you should focus on trademark or a copyright, talk to an intellectual property attorney, talk to an attorney who's familiar with trademark and copyright registrations to determine what the best option for you is. That's all for this episode, folks. drop a comment below and let me know what you think. And of course, I am happy to help if any of you are looking for assistance with trademark or copyright registration. My contact information is in the description, and you can learn more about my all-inclusive trademark registration package called Brand Bombshell, where I take care of literally every step of the process for you. Or if you're on a tighter budget and looking for more of a budget-friendly option, you can check out Brandish, which is my online DIY trademark application course. So again, links to both of those are in the description below. Thank you all so much for watching. I'm Aiden Durham, and I'll see you next time.